All right. So welcome everybody. Today we're going to go over all of the buyer forms that you guys typically are going to be using. And I'm going to touch on all these forms. I'm not going to go over every single section, but I'm going to touch on most of the sections in each form because a lot of times the nuance of each form kind of gets overlooked, and we start getting in the habit of going from blank to blank and filling in that information and not being always super aware of what all the words in between the blanks are saying. And it doesn't help that we've had so many forms changes over the last couple of years. If you aren't being intentional about just reading through these forms on a regular basis, it would be easy to miss some nuance of them. One change that has been really great is that our buyer agency agreement is only 3 pages now. I think it had gotten up to 8 or 9 or 10. Heck, maybe it was like 12. I don't know. But they have carved it down to 3, which is good. But what it also means is they moved a lot of the information that was there that was meant to be delivered, well, mostly to the client, but also to you, to the agent. They've moved a lot of that to the guidelines form. So I'm not going to go over the guidelines form today. That is something you can go back and read, but I would make it a point to do that. To look at the guidelines. It's a little more kind of natural language coming to you from the people that created the forms, telling you what they intend with these forms. The next thing I'm going to say, just as a quick preface before I just jump into each of these forms, is these forms are not a cure-all for any legal consequences. These are forms that attorneys have written, oftentimes collectively from the NC Bar, NC Realtors, and NC Real Estate Commission. But guess what? None of them are the judges that will be hearing a case that involve one of these forms. Those judges are the ones that make decisions. A good example of this is that our forms say if you were to sue a client and win, that you would be owed a reasonable attorney and court costs. But guess what? In North Carolina, almost never is a judge going to award you attorney fees. So just because our form says it doesn't mean that that becomes this magic pill to be served up to you in a court of law. So I want you to be aware of that, that these forms are the best effort of the governing bodies to give us all a unified kind of guideline on how to operate and how to do these transactions. It is not a magic pill that says, oh, there's never going to be any legal liability. Remember, these are legal documents, legal forms. So, with that, let me go ahead and jump in. Just a quick, rough overview of the forms I'm going to touch on today. And by the way, if you have questions, raise your hand. I do have your screens up, so I should be able to see them. If you have questions, just raise your hand. I don't mind getting them as we go, but that way, if you talk over me, it mutes both of us out. And so if you raise your hand, I'll get you in to ask questions. We're going to touch on the working with real estate agents, the showing agreement, exclusive buyer agency, briefly on non-exclusive buyer agency, professional services disclosure, inspection and services disclosure. Oh my gosh, did you know there are two things that sound alike? And the affiliated business arrangement disclosure. I'm also happy that one of the agents on this call is the one that probably was most influential in me making the inspections and services disclosure required. I may not call her out, or maybe I will when we get there. I don't know. Um, I don't like to require things that aren't necessary, but this was just such a helpful thing to help protect you and your clients that we had to do it. All right, let's jump in first to the working with real estate agents brochure. Um, Amazingly, I have like the second most bullet points of things to talk about on the shortest form that we have, which is just a one pager. First thing is make sure you have actually read the note at the top that says important because it explains to the client what they should be expecting from you. And if you don't deliver on that and they read it, well, that really makes you look bad and could get you in trouble. For instance, it says that real estate agents are required to review this form with you at first substantial contact before asking or receiving confidential information. I mean, think about at an open house. These people come in and start talking to you, and you haven't reviewed working with real estate agents. Now, I realize that, I mean, I'm not going to call anybody out, and you get in the flow of an open house. It could be really challenging. There could be 6 groups in at the same time. I get it. Just be aware, at least be crystal clear of what your obligations are so that how you choose to talk to people, at least you're making a decision and in full knowledge of what you are or are not doing right. I think an important thing with this document and I'll just kind of give you my 2 cents on how to explain it. But you need to have just a quick, simple way to explain this form that is natural and comfortable to you. So think of this as kind of your Mirandizing, the Miranda rights for a buyer or seller. You have the right to remain silent. If you don't, anything you say can and will be used against you until we decide to work together. Once we decide to enter into agency and I'm your agent, now all of that we have client attorney privilege, right? Now you can tell me everything and I'm there to protect your best interests. But make it simple. You should be able to explain this form in 30 seconds or less. This is a required disclosure that North Carolina has because we want consumers to be educated on their options when they work with real estate agents in North Carolina. The main point I want you to take away from this is until we decide to work together, don't tell me anything you wouldn't want the other side to know. So if you're talking to a buyer in this case, don't tell me anything that you wouldn't want the seller to know. Once you and I decide to work together, fantastic. Then tell me everything because now I'm your advocate. It could be that simple. Okay. If you try to go into all of the nuance of dual agency and designated dual agency, you're just going to start stumbling over it. The main thing is don't let these people tell you stuff that is personal and confidential until they have been told that they shouldn't tell you that stuff. And then if they want to blab about it, fine. You've explained it to them. Okay. So work on that 30-second elevator pitch. Keep it simple, stupid. You're going to have plenty of time to explain the nuance of dual agency and designated agency later. Okay. All right. Oh, one more thing. So, well, maybe a couple more things. It says up here, underline the word not. This is not a contract. Sometimes you'll have people that just will not sign anything. Look, I am kind of one of those people, or maybe I used to be. Maybe I'm just so beaten down in real estate. You got to sign so much stuff. Maybe I'm not so bad anymore, but I don't like to sign stuff until I've had a chance to review it. But if somebody is taking that position, just know it says the very first sentence this is not a contract. There is nowhere for me to sign it to say that we're agreeing to anything. This is a unilateral disclosure I'm making to you about the way consumers work with real estate agents. You are only signing for compliance purposes, so I can prove that I gave this to you and went over it with you. If that doesn't put them at ease, then just come down to the bottom, on the very bottom right, refuse to sign, and have them initial it. And they will do that every time. They will either at that point realize they're being stubborn and ridiculous and just sign it, or they will initial the thing saying that they refuse to sign it, which is amazing. But I've never heard of anybody not being willing to do that. If they still wouldn't do it, I would take a picture of it. I mean, you should be able to get their name. So I would write their name on the form, take a picture of it, and email it to yourself so that you have a record of that. Okay. Um, it seems like a little bit extra steps, but this is just protecting yourself. All right, as far as how to fill it out, you're going to check these, but this gets so messed up and confused all the time. If this is somebody you're meeting at an open house, you have no idea how you're going to potentially ever work with them. So you're going to check all 4 boxes because this says keyword here. I wish I could highlight it. Check any relationship types that may apply. Not that you think are going to apply, but that could apply, that may apply. So if you don't know, you just check all 4 of them. All right. Now, if you just got a referral or past clients coming and you're filling out this paperwork, guess what? You know they are not going to be unrepresented. You are literally sending them all the paperwork to sign right in this moment. So then you're just going to check the first 3 because they could end up being exclusive buyer agency, dual agency, or designated dual agency. You don't know which at that point, but you know they're not unrepresented because you are literally sending them an agency agreement along with this. So check the boxes that may apply in any given circumstance. Any question about that? Perfect. Make sure I've got everything else. Yep, perfect. All right. If there's no questions about working with real estate, oh, Allison, go for it.
Look at the chat.
All right, I'm gonna have to have a helper on chat. If I bring chat up, my screen will be too full. Is there a question in there? Kate, can you see it?
Yeah, so they were just asking about whether you're checking buyer agency dual designated or unrepresented. Usually I just do the top three. And so but you already explained it that check all that may apply. So if it's a brand new buyer or client, then you can check all four.
There you go. That's right. So thank you for that. And I can get the chat up. Sorry to be so dramatic that I can't get it up. I see it now.
Okay, and then there's one other question about, does this also apply to builders? Sorry, agents that represent builders.
Well, yes, if you are working with the builder will sign that as your client. But as a buyer, I mean, this is just, we're looking. So remember, there are two different versions of this now. In North Carolina, it used to be one, but we have two different versions that are slightly different, one for buyers, one for sellers. This is just speaking on the buyer's side. But yes, whoever is your client, whether it's an entity, if it's a builder, if it's a person, if it's 10 people, you're going to have everybody involved. If it's an entity, just whoever is the has signatory authority for that entity, that's who you would be disclosing this to. By the way, there's no harm in getting to this signed by more people than need to sign it, right? No harm in having extra people sign it. But to be clear on the which boxes, it's whatever ones may apply. So if you don't know, then it could be any of the four. The person at that open house or that sign call or whatever it is, you may never end up working with them. So they need to understand what an unrepresented buyer means and that that could be an option. But generally speaking, when you're just signing up actual clients, it will be the top three, as some of you indicated in the chat. All right, Wendy.
What about all the unrepresented buyers that call on listings? I mean, a lot of times they just start giving their own information away,
Yep. So you have to
and it's a
stop
phone
them.
call.
Yep. So you can review what working with real estate agents means and explain the implications of it without, excuse me, providing the actual form. So when someone calls and starts telling you all of their, hey, I've got to have a house by Saturday. Um, Time out. Just remember, Mr. Mrs. Unrepresented Buyer, I represent the seller. Anything you tell me, I will need to convey to the seller. So just be aware of that. And you need to make that's the point that needs to be driven home to the consumers. That's what's going to keep you out of trouble. If they tell you that they need to buy a house by Saturday and they'll pay anything for it, and then they end up being an unrepresented buyer on your listing. They realize later they overpaid. They remember they told you all this information. They file a complaint with the real estate commission. Are you going to be able to defend yourself? So make sure people understand. Don't give me any confidential information until you want me to be your agent. And look, in the real world, I realize how difficult it is. Don't forget, I sold real estate for a long time. I understand. The rules are the rules, and you want to make your best effort to do right by people. And if you do that, you're typically going to be okay, even if a complaint was ever filed. Okay. So do the best you can out there in the wild. But know the rules, know what you're obligated, know what you're supposed to do, and then do the best you can to be moving towards that at all times. All right, wonderful. Let me move in next to the property showing agreement form 202. Everybody knew this so well. I hope you all still know it really well because every time you schedule a showing, you have to check a box that says you have some type of written agreement with that person before you go show the house. This is the form that's easiest to do that with if it's just some random person. So if you're not ready to get into agency with them or they're not ready to get into agency with you, this is the form you would use. You have to have some kind of written agreement before you show a house. That's not just in North Carolina, that's every state in the union. This is just the form that North Carolina created for us if you weren't ready to get into agency. I would simply, the way I would explain this, or I'll start with this, is I would just tell a consumer that, hey, this due to recent federal regulations, all consumers have to have some type of written showing agreement prior to viewing a home with an agent who is not the listing agent. So obviously, if you are the listing agent, you don't need anything because you represent the seller. Well, you don't need anything other than working with real estate agents. Hopefully, I've established that always needs to surface. But you don't need a showing agreement if you are the listing agent. However, for every other situation, you need to have this signed. The reality is, if they won't sign it, you don't show it. And so if people can fight you all day long on this, and I realize that happens out there in the real world, but if they don't sign, you don't show. Just remember that. I think a lot of good strategy for this is sending this to them ahead of time so that they see it, they can review it, they can have Chat GPT look at it, whatever they want to do, And you can either have them sign it ahead of time, or you can send it to them and say, hey, I wanted you to have this to review due to federal regulations. Everyone who goes to view a home with any agent who is not the listing agent has to have a signed written showing agreement prior to viewing the home. I want to send this to you in advance so that you can review it. I'm going to have a copy when we meet at the house, and I'll have you sign it then. Let me know if you have any questions in the meantime. What you don't want is to waste your time going out to a property only to have somebody not be willing to sign it, and then you can't show them the house. The reason why this is important is this is what protects agents and brokerages from being sued. If a consumer were to try to sue you and you realize it was discovered that there was no written agreement, you are now not protected by the NAR settlement. All the terms of the settlement that protect all of us brokers, brokers meaning agents, don't apply to you if you don't follow the rules of that settlement. And this is one of the rules of the settlement. So it's not just a box you click when showing time, when you're scheduling a showing. There's actually real legal implications to this. It's not a big deal. Agents do it all over the country, 1.5 million realtors. Just get it signed. All right. Let me touch then briefly on some of these relevant sections. Section 1, the service, the scope of the services you're providing. So this can be for a single property, or it can be for all of North Carolina, whatever is appropriate for the scope of services that you are offering to that consumer in that moment. It can be Cary, Central North Carolina, Wake County, North Carolina, or it could be a property address. Okay. Then it asks you for the compensation that if we do go into agency and I help you write an offer, how much do I expect to get paid? Put in whatever you would be putting into the buyer agency agreement. So I won't go into numbers, but just whatever number you would be putting into your buyer agency agreement, put that in there. It's just informational. It is not committing them to anything. But that way they have an understanding upfront of what you expect to be paid if you guys decide to turn this into an agency agreement. Section 2, this would be easy to just gloss over. This is, have they signed anything with anybody else? You need to know this. Not only because if they've signed agency with somebody else, then you're not supposed to be doing anything with them. So you want to get to the bottom. Buyers sign stuff all the time without knowing what they're signing. I mean, this has come up so many times that people find out they've signed an agency agreement with somebody else. So asking them the question, if they may not know what they've signed, but if you ask them, have you signed something? They usually know that, and they may still lie to you, but at least you've asked the question and didn't just gloss over that. But it's also important for procuring calls. If they've actually seen that house before with somebody else, you may show them that house. You may then go into agency, write an offer, and close that deal and have to give your commission back because you weren't the procuring cause. It has happened at Choice Residential. So be aware that that matters. You need to ask questions. You can still be lied to, and that you may be able to go sue the client, but you may get called in front of a committee at the Board of Realtors who makes a determination that you were not the procuring cause and that commission is owed to another agent. So there, obviously that kind of stuff does not come up a lot. But when you are meeting people you don't know, where like even if they are going to sign this form is in question, those are the types of situations where this would occur, where they may not be completely forthcoming with you. So my point is, make sure that you are having that conversation, not just treating this like a little checkbox, but having the conversation. Have you seen other homes? Yes, I have. How have you been seeing those other homes? That right? They may tell you they don't have an agent, but they just told you they saw other houses. Somehow they got into them. Now you want to start peeling that onion back. Stacy Potter.
Yeah, quick question related to having a showing agents. Like I already have buyer agency signed with clients. Do we still need to have a showing agent fill this out, or are we good as long as we have the exclusive buyer agency sign? And maybe I already addressed this and I missed it. I don't know, but
No, you're good. If you have buyer agency, you're good. And if you have buyer agency and you're paying another agent $50 to go show a house to that client, you're good.
thank you.
Yep. All right.
And
Section 3,
that's
the term of
within
the
choice too. So any choice agent.
That's right. If they're not a choice agent, they shouldn't be showing your client a house. But if somehow you found yourself in that scenario, that's different. That person does not represent the buyer. They would need a showing agreement for their own protection. But hopefully we don't even get there. There are all kinds of legal ramifications with having other agents show houses for you. All right, that aren't with choice or aren't with your firm if you're watching this from a different firm. All right, so the duration, just know it can be 1 day, it can be a year, doesn't really matter because there is like no commitment with this form. The buyer can literally send you a text and be like, this thing is terminated. It's unilateral, one-sided, either party, boom, send a text message, done. So it doesn't really matter how long you make it for. But just if you're only going to do 1 day, guess what? You show them a house tomorrow, you got to do another one. So I would make it long enough to accomplish what you want to accomplish with that client until you're going to move them to agency. Section 4, is there a fee? So this is basically, are you charging to show the house or not? Either way is fine. I would venture a guess that most people are not charging, but you would be well within your rights if you wanted to say, yeah, I'll show you a house, but it's going to cost you $50. And if they don't want to pay you, then you don't want to show the house. That's up to you. Just know Section 4, that's where you're identifying, are you charging a fee or are you showing for free? All right, Section 5, dual agency. If you're showing a house that is listed by choice, you need to say that, yes, they're going to allow you to be a dual agent. If it's not listed by choice, it doesn't really matter. If it's just for one house, if it's for more than one houses or more than one house, you would be wise to make sure that box is checked for allowing dual agency. So you're not having to redo this form because tomorrow you're showing a choice listing. All right, any questions, additional questions on that? Okay. And again, just read through the forms. What I love about talking about forms is that so much of it is black and white, like literally, because it's words on a white sheet of paper. You just have to read it. And North Carolina is pretty good about telling you what to do. That's why I like these conversations. Everything else in our business is very subjective and not black and white, but the forms are usually black and white. All right, buyer agency agreement. This is one we'll spend maybe the most time on, but I'll try not to bore you too much. Section 1, you're describing the scope of how you're going to work with them. So the type and the location of property. So this could be new construction in Johnston County if you wanted to make it specific for that. But guess what? Just remember, whatever you put in here, that's the scope of your agreement. That client can go sign another exclusive agreement with another agent for another scope of work. So the more you limit it, the more the more limited your scope is with that client. So, I would just do something like residential real estate in Central North Carolina, but you put whatever you want in there. Just know that that's what you're identifying, and it does matter. It doesn't matter as long as everything goes well and you get to closing and everybody's happy, of course. That's true for everything. You can make lots of screw ups along the way. And if you get to closing and everybody's happy, none of it really matters. It's when things go off the rails that people start looking for mistakes that allow them to get money out of your pocket. So putting, being thoughtful about what you put in there makes sense. And look, some clients are super easy and you put anything in there and they don't care. They're happy with it because they just want to work with you and that's all that matters. There are going to be other ones that are like, no, I called you to go look at new construction in Johnston County. That's what I want this limited to. And so you just kind of work through that. But knowing what all this means is important and helps you have those conversations with them. Section 2, please don't assume anything. Again, just like the showing agreement, actually ask these questions. It matters because if they're working with a relocation company, for example, you're probably giving 42% of your commission away. And also, you've got to make sure you're even approved to work with that relocation company. You could get into an agency agreement that buyer can't fulfill with you because you didn't go through the proper steps to get approved through the relocation company. So ask these questions. As far as subsection C, receiving sample copies, yes, you have to give them sample copies. I don't love the way this has always been worded because it's just kind of like, have you sent it to them or not? I wish it would say, you are required to send these to them. And like that's it. Like not have you or haven't you. And this is an acknowledgement about whether you have or not. But agents I've seen agents just say, no, buyer has not received sample copies. And the agent's like, no, I didn't send it to them because we checked no. No, you send them those sample copies and then you check that you have done it. So as you're sending agency, that's a good time to just send those documents over. If you didn't do a buyer consultation where you have those sample forms in your folder, email them over. All right. We put them in the loop so that you could do that, so that you could check the box. And when you share this to be signed, you're sharing the sample forms as well. Best practice for me would be to do those as separate emails. When you're sending them 5 things to sign already, you don't need to add in a couple extras for them to scroll through. So I would do it separately, but it's not optional. You have to send those things. Kate.
A few comments in the chat I wanted to circle to. Jessica asked if we did charge for showing. I wouldn't, but if we did, how should we receive compensation? Does it need to go through choice, is my question, or can they Venmo the agent directly?
Thank you. It has to go through choice.
How does that work? Is
They
it
send
at
us a check.
closing or is it in advance?
No, it would be in advance because there may never be a closing.
Fair.
You're just getting paid to show the house. But that is brokerage activity that you requires a license to do it. And to be compensated for brokerage activity, you have to be paid through your broker in charge in North Carolina. So I don't love it. It's not, it is a bottleneck for us. But I do love you guys being compensated for your work. So we will handle it on our end. But they just need to send us a check. That's the best way to do it. So they give you a check made out of Choice Residential.
Gotcha. One more question. Mary asked, can we have one agreement for resale and one for new construction?
Yes, you could do that. I mean, you're talking about, I'm assuming for buyer agency. I mean, there's an argument to be made that could make, well, I don't think you actually need to do that. You can specify your compensation in this agreement that we'll talk about in a second. So if the reason you would be doing that is to say, if I'm helping you with new construction, it's 3% because that timeline, that life cycle of the transaction takes so long, great. And resale is 2.5%. Let's say I'm just using made up numbers. We're all at choice here, but just for anybody that might be watching later, compensation is not set by law. Okay. But you can do that in one form. So the scope of the work could be all houses, right? Residential, Central North Carolina, resale, and new construction. And then you can identify what your different compensation is based on the type of property later.
Got it. Okay. We'll definitely want to go into how you specify that and bonuses and whatnot. I know we're getting to that.
Yep. Vanessa.
So one of the things I started doing last year for the forms that we're supposed to send them samples of is after the buyer consultation, whether it's in person or via Zoom, I follow up with an email that has a summary of each of the forms, not just the forms. So it's like a 3-sentence paragraph for each form. I had ChatGPT help me kind of create what that looked like because I'm at the stage where I want to make sure that there's never an opportunity for them to say, you didn't talk about that with me. So if I have a paper trail in addition to the consultation, it's just become part of my process.
Love that. One thing I used to tell people is here is everything you could know about buying a house. And here's everything you absolutely have to know. I'm going to find a middle ground. I like for my clients to be really educated. And so we're going to provide you with as much information so you can be an educated consumer as you can. How does that sound? And of course, they love that. They want to be educated, but they'll also tell you if all they want is for you to tell them where to sign. Now, just because a client only wants to be told where to sign doesn't mean they won't come back and complain about it later. So, yeah, thank you for sharing that. All right, where am I? Section 3. Okay, same thing. I would just say it could be a day, it could be a year. I don't know, probably 10 years. I don't think a judge would love that. So if you get beyond, maybe 2 years, maybe don't do that. I would say probably most common we see is 6 months. It's also not uncommon for a client to push back, whether you put 6 months or a year in there. I would say 15, 20 years ago, everybody just accepted 1 year. That has gotten shorter and shorter over the course of my career. But also it has to do with the market. If you're in a market where house hunting takes 6 or 12 months, maybe you have it a longer period. But just most common, in case you're wondering, is probably about 6 months now. But don't be surprised if somebody pushes back. And I wouldn't make a mountain out of a molehill if somebody wants to do it for 3 months. You just have to make a good kind of business decision, educated decision based on your interactions with that person. Like, are they trying to get around something here, or are they just making a reasonable protection of themselves because they haven't started working with you yet? They don't know if you're terrible. Now, none of you are, but they don't want to be locked in for a year to an agent that isn't responding to their emails and isn't, communicating with them. So it goes both ways here. Just be aware of that. I would probably start at 6 months to a year. Mary.
Sorry, I'm just exercising. Sorry for the lack of a picture. um, I was just wondering, the conversation that I've always had with people who seem to think that they could get a better deal if they go direct with new construction, relates to the value that I bring to the transaction. But I just wondered if anybody else, and I know this is a little off topic, but I just wondered if anybody has anything else to add. I also mentioned that the commission, our commissions come from a separate budget, but I actually did get burned by somebody once who went and did get a better deal. So I just wondered what, when you get people who think that they're going to get a better deal if they go direct to new construction, is there anything else that anyone has said that is valid? And do we even know if that's valid, by the way?
Yeah, so I'll touch on it quickly, but I will keep us on track here to make sure we get through the forms quickly. I will just say that there are builder reps out there that will say, "Hey, we're going to give you more of this or give you a better price if you don't have an agent." You more times than not that doesn't happen, but there are those out there. We've shared those experiences on our weekend wrap-up calls. Unfortunately, there are times where that comes up. What I would suggest telling a client sounds like basically what you do. That is when a subdivision is being developed, all of the costs that a developer slash builder are going to incur get built into that planning, and that is knowing that a certain percentage of buyers are going to have real estate agents attached to them, and there's going to be a cost to that. So all of that is built in. So regardless of whether you have an agent or not, you're paying for an agent, so you might as well have one. If an on-site agent disputes that, says no to that, I mean, there's nothing we can do about that other than continuing to share your value. So that's certainly a conversation about scripting we can talk more about
No, that's
as well.
perfect. Thank you, Brian.
Yep. All right, so let's get into the section that causes people the most angst or anxiety, which is section 4, which is about our fees. I'll just touch on each section here, but one thing I just need you to know is that there are no ranges and there are no clever ways to get around that. You can't say up to or at least or find some other semantics to help you put a range in there. You need to identify specific amounts. You can identify as many specific amounts as you want to. If you need to attach another page, then check this box and say, see attached exhibit A dash compensation, whatever. Okay. You can attach something. If you buy a house in Cary, I charge my firm charges 2.5%. If you buy a house in Apex, it's 2.7. If you buy a house in Sanford, it's 15%, right? Whatever you want to do, you can do it, but it has to be specific amounts. So that applies for resale, new construction, land. All of these things can be identified separately. Once upon a time, land transactions were often had buyer agent compensation that was higher. That may or may not be true anymore. But the point is, if you have different compensation expectations, whether it's location, type of property, you probably could even do like duration of agency. Like if you have not gone under contract within 180 days, then my compensation becomes this. Like whatever it is that is. Now I would avoid doing that. You're asking for trouble if you do that. But the point is, as long as it is specific, then you can do it on here. What they don't want is any ambiguity. Okay. So let me just touch on each section. If you're charging a retainer, again, same thing. It has to run through the firm, but you can charge a retainer fee. Some agents do that. I'll just say with us, even though we have talked about it in the past, most agents are not doing that, but we have seen it a few cases of that being charged. When that happens, it runs through the firm. We have an internal process that we will guide you through so that we can track that. Nothing gets taken out of it from us. Nadia, do you have a question about? Go ahead.
Yes, I did. So what if new construction is unknown? Is it 2.5 or 3%? So, or if there's a bonus in one and not the other, how do you
So
handle that?
I'll touch on that. Okay, let me lead with this. An important concept that all real estate agents have to understand, whether we like it or not, you have to understand it and accept this. You are charging a fee to your buyer. You establish that fee at the time you're signing this form. That is not impacted by what somebody else decides to offer you later. You are telling your buyer on day one, this is what I charge for my services, whether it's X, Y, or Z. If you can't say today we're signing this agreement for X. Oh, but somebody's offering me Z later, so I'm going to take Z instead. No, 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 because we have gotten to a place where whether we agree that this is actually true or not, we're not going to get into that. Is that your buyer is paying this compensation, whether it's through the seller or out of their own bank account, they're paying the compensation. So they have to agree to a specific number upfront on day one. So now that is me sitting here on a training session telling you that. That is what the words say. That is what license law says. That's what the NAR settlement says. Now you have to go out there in the real world and sell houses. And I realize the frustration and the difficulty of saying, look, the builder is paying, this amount of money. We didn't ask for it, but that's what they're offering to the firm. But it doesn't matter. You have told your buyer on day one, this is what I charge. And if somebody wants to give you more money later, it's not your money. It's the buyer's money. Now you and the buyer could have an agreement, that they say, no, we want you to have that money. Okay, as long as the buyer is making informed decisions. What we don't want is the buyer to kind of unknowingly be allowing you to make more money than they thought you were making. So to tangibly try to answer your question, put the fee in here of what you think based on the scope of what you're working with these buyers for. What are your services worth based on what you are expecting to do for this client? How long is it going to take? Where are you driving? What type of properties are they looking at? Like, you have to take all that into consideration with what you charge as your fee, and you're going to put that in here. So without trying to get too much into specific numbers, just you're going to have that kind of mentality. And so you may put a number in here that maybe is higher than what you actually end up typically getting. And I said this 2 years ago when the settlement came out, and I'll say it now, which is that somebody has to trust somebody. If you're telling the client that, hey, look, I expect to get paid, I'm just going to make up a number here. I expect to get paid 5%. But as long as we're getting paid 3%, like I'm not going to make you pay that difference. Well, you can't put that in the agreement. You can't say I'm going to make between 3 and 5%. So they have to trust that you're going to honor that, because you aren't allowed to make more. So you can't put the other way doesn't work anymore. Our paperwork doesn't allow for that. So you can't put 3% and then get paid 5% later. So somebody has to trust somebody. They have to trust you. But if they won't, you just have to work with your client. This is a contract between two parties. You guys have to agree on a number here. So you'll put that in for your fee. The bonus, this is an important one, and this is one that even when you point this out, a lot of clients are still going to struggle with. But let's just say that we put a bonus of $10,000. Well, how the heck do you know what a builder might or might not be offering? I don't know. There's no perfect way here. That's just the way it is, So I'll say that. But you have to figure out what our builders offering as bonuses in the area, and you come up with some number. However you come up with that, and you put it in here. The buyer is not on the hook for it. The very next word is if offered. If offered. So if it's not offered, the buyer doesn't have to pay for it. It's only if it's offered by the seller or builder. But if you put nothing in here, well, you're not supposed to collect that bonus then. So by putting it in here, you're putting the buyer on notice. Hey, builder may offer a bonus. If they do, I can receive it up to $10,000. If they don't, you're not on the hook for this. Even though it says it in black and white, though, a buyer may be uncomfortable with the fact that they're signing something that says $10,000 here. So you just have to work through that with them, and hopefully they don't care. If you do a flat fee, I have not been seeing choice agents do that. I've heard minor whispers about it out in the industry of some people that do it as a flat fee. I actually don't love that. I don't love the optics of that. I don't know. I won't go into my views on why I think our compensation model in real estate as it is makes a lot of sense, and I don't think we need to reinvent the wheel on it. Other industries get things called raises, right? Their income goes up over time as the cost of things goes up. Real estate agents don't have that. However, we are a percentage-based industry. That's how we are protected against inflation, just like every other employee in every other industry is. That's how we are. But I digress. And then any other specific information, So if you charge a transaction fee, just put transaction fee, $450. I'm going to just give this quick reminder. The transaction fee that Choice charges is not a transaction fee billed to your client. You, as the agent, may choose to charge a transaction fee, but if you do, it needs to be in the agency agreement. Do not fill out the attorney's information form at the end of the transaction. And when they say, is there a transaction fee? You say, oh, yes, it's this fee that Choice charges. And then that goes onto the CD as a buyer expense. But the buyer never agreed to that. It wasn't in the agency agreement. So don't confuse the semantics there. You might charge a document management fee or a transaction fee to your client. That is for you as the agent to decide. The transaction fee we have at Choice is not intended to be billed to your client. That is for you to decide. You are empowered to make that business decision. Allison.
Okay, so if you're adding in their bonuses and you're adding in their transaction fee, what if it doesn't all fit?
Well, where would it not fit?
On other?
Well, if it's a bonus, you're putting it up here. Now, unless you were
Oh,
doing
okay.
now,
I can't
unless
see
you,
it. I can't see it.
oh,
Hold on, let
okay,
me look.
yeah, the third checkbox is the bonus.
Oh, got it. Okay.
That's how it's segmented out as only if
That's
the builder
new.
or seller newish. But yes, that was not part of the original iteration of this new buyer agency agreement. Now, again, you can attach another exhibit. Let's say, for example, you were just super diligent. Maybe you are a high C personality and you were a CPA in a former life, and you're like, well, I know that Ryan Holmes offers this, and I know that Lennar offers this, and I know that blah, blah, blah offers this. I mean, you could create a complicated compensation document if you wanted that says, here is the compensation for these builders, for these locations, for these neighborhoods, because you know all of that. Great. I've never seen it before. That seems like overkill to me. Let's not overcomplicate it. But you could, and then you would just use this other specific amount, and you would say, see attached exhibit A or compensation exhibit, something like that. If you want to make it that complicated, I suggest you talking with me first, and I'll help you through that. All right, a couple other points on this. The fee is earned as soon as you go under contract. It's payable when the contract closes or the buyer breaches. An important point, if the buyer terminates after due diligence, we are trained that no big deal. They just lose their earnest money. Well, that's true, but they're also breaching the contract. And in breaching the contract, that means they also owe you your commission. So don't tell them that it's okay if you terminate the contract. All you're going to do is lose your earnest money, and you only did $1,000 in earnest money. No big deal. And then go to them and say, oh, by the way, after they terminate, oh, by the way, you owe me my commission. There ain't a judge sitting on the bench that's going to be real happy with you if you try to sue somebody for a commission after encouraging them or coaching them or not letting them know of the true implications of terminating after the due diligence period. Okay. So just want you to be aware, even though you might be owed the commission in that case, you are almost never going to actually get it, and you're not going to sue for it. The protection period, just as a reminder, that only applies. Basically, the protection period is if you need help explaining it to a client, it's what prevents a buyer and seller from colluding together to kick their real estate agents out of the deal. So two agents bring a buyer and seller together, all is good, all is happy, and those buyers and sellers decide to collude to say, all right, they brought us together, but now they're out of here. The protection period helps with that. If the buyer signs with a new agent, done, void, gone, doesn't matter anymore. There is no protection period for that. Okay. And if anybody sees questions in the chat, just throw your hand up. All right, section 5, that's straightforward. You can read that. Dual agency, I'm not going to spend a ton of time on this, but this is, you do want to make sure if you have not gone into, Kate.
Sorry, one, and I think Allison might be answering it, but Crystal had asked, what if you initially put 5 and you and your clients agree to change it to 3?
Oh, you can take less. Yeah, you can always amend it and take less. The intention of this form is that you are not allowed to receive more compensation than you put in the form. Now, you could make a rational argument to say, well, what if we just amend the agreement? Okay, yeah, I mean, you could amend it. If you had 3 and now you want to make it 5, I mean, technically you can amend the agreement. We have an agency amendment form. That is not the intention of the form. And if you ever got called to the carpet for that later, you better come up with a good explanation, on to tell either the judge or the real estate commission as to why you changed your commission to a higher rate. And it could be a legitimate reason. It could be, well, we signed agency 12 months ago and we're still looking. Or it could be that the scope of what we're looking at changed. I mean, there could be plenty of legitimate reasons. If it's just because builder A wanted to pay me more money, I'm not sure that would fly. So, take that for what it's worth. Anything else, Kate? Okay. Dual agency. I'm not going to spend a ton of time on this, but you need to make sure you have had a conversation with your client about dual agency and that we practice designated dual agency. Dual agency, in my opinion, hopefully nobody from the real estate commission watches this, is pretty antiquated. We live in a world where agents don't just congregate on Main Street at the office and talk about all of their listings with each other. Okay, that's where dual agency comes from. It's like, well, you work for the same firm. There's a good chance you know stuff about these other clients. Well, okay, I'm looking at Allison and Nadia. What are the chances y'all know anything about each other's clients? Like literally zero. I mean, we don't live in that world anymore, right? You can't go to the office and pick up the manila folder that has all the private information of Nadia's clients anymore. Like that lives in a behind the wall dot loop, right? So so it's just a different world. Nevertheless, you want to make sure the consumer understands dual agency is when any agent at our firm at Choice is on the other side of the transaction. However, we practice something called designated dual agency, which is awesome because it allows me to continue representing your best interests. Even if the listing agent is also at Choice, they continue representing the seller. I continue representing you. Doesn't matter that we're at the same firm. We are going to work together the exact way that you expect us to be working together. Perfect. That's why they want designated dual agency. Okay. Here's the important thing I'm going to point out. If we have really deep questions about it, we'll take it offline. But your clients will almost always initial the second set of blanks here that says firm may act as a dual agent in a transaction involving this buyer. Okay, so we're getting permission to be dual agents, number one. That's the second blanks. And then the fifth blanks. That is what is the fifth blank is the buyer directing us to be designated dual agents. So they are saying the buyer does not authorize the same agent to represent both the buyer and the seller. Well, of course, because if you're a designated dual agent, you can't be the same agent, right? So it's stating what is the obvious, but is explaining it clearly to the consumer. The same agent will not represent the buyer and seller, and they will be a designated dual agent. That's what the fifth blank is doing. Now, if the situation comes up, rarely, but it does happen, where you have a buyer that has some criteria, you take a listing that matches that criteria, and now all of a sudden you already have agency with both of them, and yet both of their agency agreements say, the listing agreement and the buyer agency agreement says buyer does not authorize seller, the same agent, to represent both. On the listing agreement, it says seller does not authorize same agent to represent both, and yet you're in that situation. It's okay. You can amend this agency agreement for that situation. You can amend it so that the buyer does authorize the same agent to represent. If in fact your buyer and seller agree to that, you would just amend both agency agreements, okay? In that case, I would encourage you to shuttle that buyer off to another agent and let another agent help them prepare the offer. You will both be dual agents, standard dual agents in that scenario. So that agent can't advise the buyer and you can't advise the seller because you know everything about both of them. So that eliminates the option for designated dual agency immediately once you know information about both of them. But you still created a layer of separation by letting another agent prepare that offer for the buyer. And if it goes under contract, you can step back in. You just pay that agent a referral fee or a thank you fee or whatever. But that way it gives you a little layer of separation in the preparation of the paperwork. Dana.
Okay, so we cannot put buyer does authorize the same agent to represent both buyer and seller in dual agency.
Correct, because what we need is every client agreeing to designated dual agency. So it's not that you can't do it. You can do it eventually if you have to. If the unique situation pops up where you need that, it can be changed. But we have so many agents, so many buyers, so many listings at Choice. We can't have one agent working with a buyer where they're just operating as a standard dual agent. And the listing agent thinks they're operating as a designated agent, a designated dual agent. That doesn't fly. That creates a legal conflict that if anything goes wrong, we're all in big trouble. So we need all of our clients to be on the same playing field, which is all as designated dual agents. The only time you need to worry about representing both of them is if you actually represent both of them. Well, then you're going to know that you need to amend both of those agency agreements. But if it's another choice agent, you wouldn't know. And I can tell you, you're not going to ask. How many people go show a choice listing and say, hey, by the way, I want to confirm that you have designated dual agency with the seller? Never, right? So by default, all of them need to always be designated dual, be directing us to be designated dual agents. And if a situation comes up, you can amend that later if necessary. But that's the only way to protect, to make sure we're all playing the same way.
Okay.
And
So,
if you have a listing, so the most common scenario
right.
is you have a listing and an unrepresented buyer shows up. There's no reason for you to enter into agency with that buyer. You allow them to be unrepresented. Because if you enter into agency with that buyer, you're now a standard dual agent. You don't actually represent that buyer. And now you don't actually represent the seller, because now you're just a facilitator of the transaction. So nobody gained anything, but the seller lost your representation. So there's
Right. I
very,
used to do that all the time though, because I felt as though like I advise my clients like at the end of the day, the buyer wants what they want and the seller wants what they want. So
yep,
it,
but I know it is a really tough one, but it was always, now I'm not picking on you, because all of us were in this boat, but it was always the wrong thing to do. I mean, at least in North Carolina. I can't speak about Illinois. I know that's where you practiced. In North Carolina, we've had buyer agency. We were one of the first states in the country to do it, 30, 35 years ago. And so we have always operated a little bit differently than other states, but it was, at least here, it was always the wrong thing to do. But what happens is agents feel like they're doing that. They do it because they think it's the right thing to do, but they haven't evaluated the fact that, oh, I can just let the buyer be unrepresented. Like, why do I need to actually go into agency? Because even though you're advising, you're in your mind, you're saying, well, I'm just telling the buyer the right thing to do, and I'm telling the seller the right thing to do. But that's not, if you become a standard dual agent, it is so hard to walk that line. And now your seller who hired you, who you've been giving advice to all along, you now have to say, I can't tell you how to respond to that offer. I'm literally not legally, I cannot advise you on how to respond to that offer or how to respond to that repair request. That doesn't feel good to the seller. And if you don't take that stance, you've just stuck your neck way out there to get in trouble. So I know it's weird, it's uncomfortable. We have a number of agents that work neighborhoods, and they get a lot of unrepresented leads because they focus on a specific neighborhood, and people come to them for that. You have to work that muscle of having that conversation with that buyer, saying, hey, I represent the seller. Happy to facilitate this for you, get the offer written up for you. Just keep in mind, I represent the seller. If you decide not to buy this house, I would love to work with you and help you find another house. But if you decide to make an offer here, just keep in mind, I only represent the seller. But you are allowed to. We don't restrict. I mean, you could go into agency, and now you're a dual agent. I just always want to have a conversation with you in those situations to make sure we're on the same page of what your legal obligations are when that happens. But we don't prevent that from happening. Yeah. This is always one of the most complicated conversations. All right, so I think I have gone through that. The main thing I want you to know right now is second and fifth blanks, always. It will get returned to you if you don't, and getting returned to you, and then if you never look at it again, we haven't accomplished the purpose, right? You don't fix it after closing. We need you to have designated dual agency as your form of agency from the jump on both buyers and sellers. All right, let me touch on section 7. Again, this is one that doesn't have blanks, and so it's easy to not have read this paragraph. So let me touch on it. You are responsible for your buyer while you're in the home. They are allowed to take videos and photos of the house, of anywhere where there's no expectation of privacy. So anywhere that is in just normal full view, your buyer is allowed to take photos and videos of the house. But they cannot open up drawers or medicine cabinets. Lots of sellers have cameras in their houses these days. So, and you could potentially have a camera in a bathroom pointing towards the medicine cabinet because there's no expectation of privacy standing in front of their medicine cabinet. There is in the shower and by the toilet, but you theoretically a seller could have a camera in there and they could see your buyer opening the medicine cabinet, taking pills out. It is your responsibility to supervise your clients I realize they come with family members, with children, with whatever else. You just have to have an honest conversation with them, like, hey, we're responsible for the seller's house while we're in here. We just got to keep everybody together. So know your client, know your people, and do your best to supervise. Don't let them, if they say, hey, we'd like some privacy to go look at the house, that's a red flag. You don't sit out on the patio while they look at the house. We had that situation come up at Choice. Guess what? Sellers had cameras in there. Sellers knew exactly where the agent was and where the buyers were unsupervised, provided that evidence to the real estate commission. We don't want that. Also, make sure you're letting your buyers know sellers may be listening in. Sellers are not allowed to listen in. That is a felony for the seller to listen in, but that doesn't mean that they aren't doing it. So just let your buyers know we need to keep any meaningful conversations to outside the house and not within earshot of the front door ring camera as well. Last thing it says, and this is important, if a client ever asks you this, in this section it says that you cannot get photos removed from the listing. So if the buyer buys some house and then later they want you to like remove all the photos, the listing photos, this says that you can't do that. You're not responsible for that. Now, you may be able to. Maybe the agent will take them out. Maybe the MLS will remove them. Maybe Zillow will take them down if you drive to their office and like knock on the door because they won't respond to your email. But this is making it so that you aren't legally responsible for it. So that's important. All right, Section 8, other professional advice. I'll touch on it quickly because this is also on the professional services, but this says, I'm going to give you a lot of recommendations, or I may give you a lot of recommendations, but you should, I can't guarantee anybody's work. It also tells the client that they should seek legal advice as it pertains to this agreement. I was involved in a litigation recently, and the former client claimed that we didn't give them that the agents didn't give them the advice that they need to consult with an attorney. Okay, well, it's right here in our agency agreement that they need to consult with an attorney. Section 9, just remind the buyer, and this is important for you, if you order the inspection on behalf of the buyer's on the hook for it. That inspector wants somebody to pay him. And if you're the one on the order form, I mean, that's fine. I realize 99% of the time that you're scheduling the inspection for him. I get it. That's fine. But just make sure the buyer understands they are legally responsible for that payment, even if the deal doesn't close. This is where that section is if you need to point them somewhere. Okay. I'm going to skip down to section 13. Hopefully, I'm going to skip section 11, but hopefully the fact that it's highlighted in red lets you know you need to go read that. That's the wire fraud warning. But section 13, what is relevant here is that the buyer cannot unilaterally terminate this agreement. So it says it in black and white. Buyer doesn't get to just say, I don't want to work with you anymore. And it also gives you permission to charge them something if you're going to let them out of the agreement. All right, so if you're using Form 720 to terminate an agency agreement, great. There's a blank on there that says I'm being reimbursed for expenses. This paragraph is what sets the stage for that. But it is not unilateral. And then the non-discrimination, section 14, real simple script. I can talk about properties, not people. So if your client wants to know if there's any kids in the neighborhood, I can talk about properties, not people. You're not even allowed to coach them through how to go find out. So don't say, well, why don't you show up? School gets out at about 3:30 here. Why don't you drive by at 3:30 and see how many kids get off the school bus? I can't talk about kids in the neighborhood, but why don't you do that? You just did the same thing. You're not allowed to coach them through that. Now you can tell them there is lots of geographic information. You can point them to like census websites, things like that, but don't try to be super clever. Or at least if you're going to, make sure this is a client you know and trust. If you're telling them to go count basketball goals in the neighborhood, all right. Any questions about that? That's actually it. 3 pages. Oh my God, Dana, you came to North Carolina and started your career at such a great time. This agreement used to be or your North Carolina career, you've had a long career, but this agreement used to be so much longer and more painful to go through.
Selling should be free will.
That's right. All right. All right, good. If no other questions, I'm going to move on super briefly to the non-exclusive. This one you probably didn't even know existed until the NAR settlement, and some of you may still not know that it even exists. Almost never are you using it because it is almost the same as the exclusive buyer agency agreement. In fact, it's like verbatim, basically the same, except for a couple of really key, really significant differences, which is that there is an option to make it so that the buyer is not responsible for the commission. So in the exclusive buyer agency agreement, that's not an option. Whatever I put in there as my fee, I am obligated to try to get it from the other side, but if I can't get it, buyer's paying it. In this one, there is a checkbox that says buyer will or will not be responsible for paying the firm's fee. So if you are trying to, if a buyer has a concern, hey, I don't mind you getting paid. I just don't want to be the one paying you. And you can't come to terms with them, but you still want to give it a shot, you can use the non-exclusive and say, all right, here you go. You're allowing me to get paid if I can get it from the other side, but if I can't, I'm not gonna get paid. Then you got to, get out of this agreement. So not an ideal situation. But also the fee is only earned if you are the procuring cause. Meaning if that buyer goes and finds a house on their own, a FSBO, or they just go on Zillow, find a house, call the agent, go to an open house, whatever, you weren't the procuring cause and you don't get paid. You're not owed a commission. The exclusive buyer agency, it doesn't matter if that house fell off of Mars and into their lap. You get paid no matter what once they close on a house. All right. But not in the non-exclusive. So again, almost nobody is using this, but it is there in case there is a situation where it would make sense. Any questions? All right, we are in the home stretch. We've gotten through the painful stuff. We're going to fly through the rest of this. All right, professional services disclosure. Form 760, it is required at choice for all buyer transactions. The reason is this is a CYA form. If you don't know what that means, ask your neighbor. This is to protect you, okay? The way I want you to use this form, it does say, hey, again, agent's not responsible for the quality, the craftsmanship, the work, or whatever of the people we recommend. Now, by the way, that doesn't completely take you off the hook. Like I said at the beginning, a judge can still hold you responsible for something if they want to. Recommend people that have been vetted to some degree, okay? And that you, ideally, that you would work with as well. If you wouldn't work with them, you shouldn't be referring them to a client. But what I want you to do with this form, by the way, we have amended the way that you fill it out. Instead of having to get initials, and yes, I know, it says initials right here. Client is supposed to initial it. That's really cumbersome. So we have made it so that you can just put an X in there. Now, if you don't like that and you want them to initial it, by golly, you can go pull the standard mapped out form from the templates and have clients initial it, okay? But we've decided to make it more simple, in our opinion, where you can just put an X in there. So what you're doing, this is your accounting of what did they want, and more importantly, what they didn't want. Because if you order a home inspection, the home inspection gets done, well, it got done. So whether or not you put the X here for home inspection, well, once the home inspection is done, it's done. It's like, we know it was done. It doesn't really matter if you put that X there. But it is really important if you ask them if they want an HVAC inspection and they say no, that is really important that you put an X there that they waived it. Now, you're going to hopefully have an email or text message somewhere where you said, hey, do you want HVAC inspection? I encourage you to get it done because the home has natural gas heat and there could be a crack in the heat exchanger that you wouldn't know unless you have an HVAC inspection. You can say all that. Hopefully in writing, because if they say, well, no, I don't want to spend the $150 to do that, fine. But after closing, when they find out there's a crack in their heat exchanger and they've been breathing carbon monoxide or they have to replace the furnace, they're going to forget that they said they didn't want that. And their neighbor or the person that comes to replace it is going to say, well, didn't your real estate agent tell you to get it inspected? We do those inspections. It's only $150. Now they're going to blame it on you. And you now have this one sheet of paper that says, nah, nope, you said you didn't want that. Like, remember I told you that. So this is your accounting. This is a living, breathing form. You don't need to send it on day one with your agency agreement. It does make sense that you would do this like at the end of the due diligence period. You would go through this. By the way, this is to help you remember, oh, there's a hot tub at the house. Did you know the hot tub can get inspected? Well, if you didn't and it's broken later, they might come to you. We had this happen to an agent. Wrote $1,000 check to the buyer after closing because the hot tub needed to be repaired. and they weren't advised that they could get it inspected. And guess what? The company that came and did the repair said, well, didn't you get it inspected? As if he has any idea what it's like to be a real estate agent. But the agent got put in an awkward position, wrote a check for $1,000. So this is a reminder for you of what you should be advising, but there's open spaces down here. This is not an exhaustive list of what a buyer could be doing. So come up with, what are the other things I need to be recommending? A roof inspection, a chimney inspection. Do they want a plumbing inspection or sewer scope? Right? Any of these conversations, these little key buzzwords you hear on our weekend wrap up or you see posted in the Facebook group. Oh, that's another thing that somebody could potentially want inspected or tested. You can add that to your list here. So this is just a good CYA form. You don't need to overcomplicate it. You can just say this document says that while I might make recommendations to you, I can't guarantee anybody's work. I think that's obvious to you. Of course, I'm only going to recommend to you people that I would work with myself, but make sure you're always vetting them and comfortable with them. It is your money you're spending after all, Mr. and Mrs. Buyer. And then you wanted this, you didn't want this. If you make them fill out something that says they don't want a radon test, and say, hey, I need you to acknowledge that you didn't want a radon test. That might cause them to want a radon test, right? Once you start wanting to document their no, they realize how important it is. Same thing with a survey. So speaking of surveys, there is a note down here about surveys. It's highlighted in blue. It's a longer paragraph than probably it needs to be, but it's obviously shows how important getting a survey is. So if somebody doesn't want to get a survey, you may want to say, okay, great. I'm going to do a joint email with the closing attorney to let them know you don't want a survey, and so that you have an open line of communication to ask them about the survey. That's another good way to get them to just buck up and pay for it. By the way, if you didn't see it on our Facebook page this week, someone posted a survey they just had done for a client. The house is sitting right over the property line, splitting 2 lots. Get a survey. All right, that's it for professional services. Any questions? Again, it is required only for buyer transactions. We don't require it for seller transactions. But you
No
can have them
questions,
sign
but
it.
I just wanted to chime in. I know this is a little counter to what a lot of people do, but I always did this basically as soon as people went under contract. I would keep the excitement, like get checks delivered, make sure they felt the vibe, and then I would say, hey, by the way, tomorrow we need to schedule a call to go over a form called the professional services disclosure. We're going to schedule all of your inspections. And then when I would go over this, I just joke and be like, this is my version of a flight attendant speech. It's going to be long-winded. It's a little boring, but it's going to cover everything we want. It's malleable though. So we're going to select whatever it is that you want right now, and then we'll circle back to it. But this is so you know all of your options. And that just kind of sets the tone because they don't know what they don't know. So I just wanted to put that out there.
You can just imagine Kate guiding her people through. She used to sit in the office and I would hear her talking to people and how she prepared. Just fantastic. What a wonderful servant leader you are and were to your clients. All right, I'm going to jump in next one to the inspections and services disclosure. The professional services disclosure is a standard North Carolina form. As you can see by the formatting here, this one is not. This is one that we created in-house. And the idea was we want educated clients. We want them to know all the things to consider when buying a house. There's a lot that theoretically a person could care about. And it is really hard as a real estate agent to just know all of that. So to be honest, I created this really for our agents so that you had a good list of things to go through, and that because I know that you can, I mean, what do we have? Like 30 or 40 things on here. It's hard to just have all that and be like, when you're talking, when having that conversation that Kate was just describing, like, oh, I'm going to go through these 28 things that you need to be thinking about. So like you give them this document, say, hey, there's a lot that a buyer could be thinking about or care about during the home buying process. Just want to give you this sheet. We want you to be an educated home buyer. So this just gives you different things to think about. Read through it. If you have questions about any of it, let me know. A lot of the stuff we'll be talking about as we go through the process, but just want to make sure you are an informed consumer. So it just gives like a preface for maybe you don't really know how to talk about masonite siding. Well, this just kind of gives a little preface for that to give them something to start the conversation with. And you're just having them sign it. So just send it over with your agency paperwork. This is just information form. There have been things that we have added over time. There could be new things that we add over time. there's one in here. Here it is, the water from the Cape Fear River, for example. This was not on the original version of this, but it's something that a lot of agents aren't experts on. And it is something that everyone in North Carolina, because Cape Fear is the water source for a lot of municipalities. And so something that everybody needs to be aware of, not just in Eastern North Carolina. Well, good. Now it's on here, right? Now this is like proof that we as an agent try to educate our consumer. If you were to ever get called in front of the commission or, God forbid, a judge in a civil litigation, you want to be able to convey that you have done your job as an advocate and a fiduciary for your client. And if you show that you provided this to them, well, that's a pretty darn good start to your professional relationship, that you are making every effort as a professional to inform your client on their options and be their fiduciary. So this sets the foundation for if something were to go wrong later, they can't just say, oh, you screwed up. Like the question is going to be, well, like, what did you do to be a great agent? This is a great start. And all you're doing is having them sign it. So read through that. This is a good one for you to just look at. It may trigger some things for you. The last one is the affiliated business arrangement disclosure. Again, this is just a RESPA document. Choice Residential has ownership interest in a title insurance company. The other side of that partnership is Sterling Law. You all know all of this, but this form is required by RESPA. This format you have seen before. Almost every time your buyer buys new construction, the builder has an affiliated business arrangement disclosure for title and for mortgage and maybe other things too, depending on how big the builder is. This is that same format. Insurance rates are set by the state of North Carolina. So that's what these things represent. They literally just get these prices offline. So the price isn't different just because it's a joint venture that Choice owns. But the way to explain it to your client, just send it with buyer agency and say, my brokerage has ownership interest in a title insurance company, and federal regulations require that we disclose that to all of our clients. That's all this is a disclosure of that. Boom. And they sign it. Do any of you have questions about this form? Because the buyer could come back and say, well, I don't understand it. And I want to make sure you can explain it. And that's true for any of the forms we went over today. I can explain it to anybody if they have a question, but I want to make sure you can. Okay. We went over. I certainly would have hoped to do this in an hour, but I love that there were questions. That's the most valuable part of any of this. I can talk about what I think you need to know, but what you ask me is what you actually need to know. So I will allow any other questions. And if you need to hop off, please go for it. I will stay and answer whatever questions you guys have, and we'll keep the recording going for that. Donna Lewis.
Hey, Brian, real quick, as I'm watching the chat, and I was expecting Kate to catch it, but Tammy asked a good question when you were talking about the agreement. And then when we went out and showed houses, you did make a statement that said we should not open cabinets and cupboards. And her question was, can we open them to like look under sinks or something? Can you just make sure the audience is clear on what we can open, please?
Yeah, thank you. Absolutely. That is a fixture in the house. So, opening up a kitchen cupboard is no problem. Open up a bathroom cupboard to look at the sinks is no problem. You should not be opening dresser drawers. You can open a medicine cabinet. I mean, that is built into the house as well. But like, for example, I have built-in drawers in my closet. Well, yeah, those drawers are going to convey, that's a fixture. You better be really careful how you're opening that drawer and how much time you're spending. If you're just making sure it opens and it's not stuck, okay, there is no reason for that drawer to be open more than half a second. So you just need to use good judgment there. But yes, you can absolutely evaluate the home for the purposes of what is conveying with the home. Because so the way I always look at all this stuff is if you had to defend yourself, if there was a camera in the closet and a seller said, I saw you going through my drawers, would you be able to look at that footage and say, yes, I opened your drawer. As you can see, I was not looking through any of your stuff. I was clearly looking at the hinges. Okay. Like, you got to be able to defend your actions in front of the same video that they're watching. And if you can do that, I 100% have your back. If you open it up and are doing like this, you're on your own and you're in trouble. Were there other questions I didn't catch in the chat? All right, you guys are amazing. Thank you so much. I appreciate you listening to me talk about paperwork. I know that is awful, but it is important. If you have questions that hit you afterwards or that you just felt uncomfortable asking on a recorded Zoom meeting, don't worry, reach out afterwards. Happy to go through it with you. All right, take care, everybody. Thank you.
Thanks so much.